Hello, this is Shruti Nandwana, Assistant Professor of Law from Dharmshastra National Law University, Jabalpur. I will be taking up the course on Law of Torts. This is the introductory session, and we will have a detailed discussion on what is Law of Torts, what are the essential of Law of Torts, what are the different elements of it, how is it a tort different from crime, and what is injuria sine damnum and damno sine injuria, and what is malice in law and malice in fact. These are the major topics which we are going to cover in this lecture. So to begin with, let's understand what does this word tort mean. So the word tort has been derived from the Latin term tortum, which means to twist. Now what do you understand to twist? Which means something that is crooked, and in legal sense something that is not straight or lawful. So anything that is crooked, twisted, or unlawful becomes a tort. Now this is also equivalent to the word wrong in the English language. This branch of law consists of various torts. So tort is not one activity but multiple activities. So by multiple activities, I mean there might be different acts which might result in torts, or wrongful acts whereby the wrongdoer violates some legal right vested in another person. So there has to be two persons here, a person who's the wrongdoer and who infringes or violates that right of another person. Now, the law imposes a duty to respect legal rights vested in the members of the society, and persons making a breach of that duty is said to have done the wrongful act. It is essential to understand that the word legal duty or legal right is essential here, not a moral duty or a moral right. As we move on in the lecture, I'm going to explain this term further, and I'm going to explain in detail what do I mean by a legal right and a moral duty or a moral right. We move on to the various definitions. Now, our Limitation Act of 1963 defines tort, which says tort means a civil wrong, which is not exclusively a breach of contract or a breach of trust. Now, what do we mean by this? So it means that torts is a wrong which is civil in nature. Why civil? Because it is differentiated from a crime, a criminal wrong, and which is not exclusively a breach of contract or a breach of trust. Now, a breach of contract is a separate area of law which is dealt by the contract law, and a breach of trust is dealt by the trust law. So we will understand this also in detail in a few more slides. The next definition is by Salmon. Why Salmon and Winfield are discussed here? Because they have propounded two different theories, law of tort and law of tort. So what does Salmon say? He says it is a wrong, a civil wrong, for which the remedy is a common law action for unliquidated damages, which is not exclusively the breach of a contract or a breach of a trust or merely equitable obligation. Now, a civil wrong, I've already told you, as differentiated from a crime. And what are unliquidated damages? Damages which have not been quantified earlier. So, for example, if I have a contract to supply, for example, this watch, and this watch is of 10,000 rupees. If I do not supply this, the amount which is decided as per damages would be 10,000 plus some amount, say 2,000-3,000 rupees for the inconvenience cost. But in torts, there is no fixed amount which is decided prior to the breach of the right. It is decided when the tort happens. Depending on the magnitude of the wrong which has taken place, we decide what is the wrong which has happened. And here again it says not a breach of contract or a breach of trust or merely equitable obligation. See, here also it says it should not be an equitable obligation, an obligation in equity or morality. It has to be a legal obligation. And Winfield says tortious liability arises from the breach of duty primarily fixed by law. So all these definitions have made one thing clear. A duty has to be fixed by law. And this duty is towards persons generally. So in a contract is between two people. Right? If I contract to sell you this watch is to be sold to you. It is not against everybody. But a duty not to do nuisance or negligence on the road is a duty towards everybody. So that is a tortious liability. And It is not against any specific person, it is against people generally. And its breach is redressable by an action for unliquidated damages. For example, if I create public nuisance, there is no amount which can be fixed for the nuisance that I cause. And that is why it is essential that you understand that there is no fixed amount which is there in cases of damages for torts. Now, the term in common law system for civilly actionable harm or wrong, or and for the breach of law dealing with liability of such wrongs. So basically, any civil wrong and the liability for such wrong is dealt with under the law of torts. Historically, there was no general principle of tortious liability, and the King's Court gave remedies for various forms of trespass, for direct injuries, and later allowed an action on the case for harm indirectly caused. So this is the growth, this is the history of how torts came in. There is no general principle of how it began or how it grew. It was the King's Court which gave remedy, and this is how the law grew up. Other forms of harm later became redressable, like libel, slander. Distinct form of actions developed to redress particular kinds of harm, so that the law of torts was concerned with a number of recognized wrongs, each with distinct requirements and procedures. So this law developed in common law on a need to know basis. What do you understand by need? Not need to know, basically on a need basis. So whenever there was a wrong, there was a particular action which came in. So for example, battery and assault, libel and slander, negligence, nuisance, vicarious liability, all these grew slowly. There is no one law which says that this and this is right and this is wrong. It grew slowly. Now, tort was added by statutes also. So, for example, fatal accidents and new grounds of liability. For example, in India, we have absolute liability, which is not recognized anywhere in the world except for India. Case laws also extended the liability. So earlier torts was only concerned with physical injuries. Now it takes into account mental injuries also. Now there were earlier only intentional harms, then it became negligent harms also. That is failure to show the standard of precautions deemed necessary in circumstances. So this is how torts grew. It grew with the growth of society. As society started and identifying new wrongs, the law of torts also started growing. The law of torts is a collection of circumstances in which the court will give a remedy, normally by way of damages, for legally unjustified harm or injury done by one person to another, rather than a general principle of liability applicable to manifold cases. See, the crux of law of torts is that somebody has suffered a wrong, and what you do, you bring back that person from the wrongful position to the right position back again. Tort and crime sprang from common root, but have diverged in many respects. But it is still true that many common law crimes are also actionable as torts, but the same is not correct conversely. See, ideally, all laws started growing in the common law. Common law has brought in various wrongs, but crime became codified. There can be no crime without a law specifying it to be a crime. But torts grew through case law and through precedents. And it is absolutely true that an assault can be a tort also. But it is not necessary that it is a crime. Unless and until the law specifies something to be a crime, it cannot be put into the category of a crime. Now, what are the different types of tort? Now, there are a variety of torts. First is negligent. By negligent, you mean there is no intention, there is no thought. So, negligent torts, as the name suggests, are torts that are caused by negligence of the tortfeasor or the person who commits the tort. So, I negligently cause injury to somebody. I negligently drive. Rash and negligent driving, correct? So, I drive on the road rashly or negligently. This is a tort. I did not intend to cause any harm to somebody, but it happened as a result of the driving. Then also I will be liable under torts. This is also actionable under a law. So these are categories which are overlapping, but I will tell you that when can you go for torts and when can you go for crime, and can you go for both also? We will discuss this in detail. Now, what are intentional torts? Intentional torts means that somebody you intentionally does something. Malicious prosecution is one example of this. You prosecute somebody with the intention to cause harm. Malicious prosecution. Now, strict liability torts. Some torts require that there has to be an intent to do a wrong. But in cases of strict liability torts, the intention is not of question. For example, if I store here dynamite, I store dynamite in my house and it blasts. There has to be no intention of proving whether I'm doing right or wrong. The mere fact that I'm storing a hazardous substance in my house brings in liability to me. So strict liability torts are torts where the law has determined that some activities are so dangerous that an individual engaging in those activities is liable for damages, regardless of the intent or negligence resulting in the harm. Okay, I store a lot of animals which are prohibited. So, for example, I store a lot of snakes in my house, and one of them escapes and causes injury or bites somebody, and that person gets injured. There has to be no intention which has to be proved. The mere fact that I had dangerous things on my property brings in the wrong liability on me. Now, there are other categories. We are going to study all these in details and categories of these. Now, these are categories which again we are going to read. Torts affecting person. So, trespass, negligence, they might affect me. Somebody trespasses my property, I might get injured. Torts affecting family, wrongful death of relative, these are also categories. Affecting reputation, libel and standards. These are two categories which we will study in detail. Affecting property, trespass to land, goods, nuisance, conversion. Torts affecting economic rights. Deceit, inducement of breach of contract, injurious falsehood, etc. And certain other torts which are not kept under these categories, which can be conspiracy, for example. Now, what are essential of torts? Till now, we've understood that there are various categories of torts. We've understood what are there. We've understood definition. Those definitions can help us to understand what are essentials of a tort. Those definitions are what are told here as essential. So it says, torts is a civil wrong which is redressable by an action for unliquidated damages, which is other than a mere breach of contract or a breach of trust. So the first is, torts is a civil wrong. A civil wrong other than a breach of contract or a trust, and which is redressable by an action for unliquidated damages. Now let's go on and understand each of these elements in detail and a few details under those elements as well. So it says, torts is a civil wrong. Now, the basic nature of a civil wrong is different from a criminal wrong. In case of a civil wrong, the injured party, so who has been injured, who has been wronged, that is the plaintiff, institutes civil proceedings against the wrongdoer, that is the defendant. In such cases, the main remedy is damages. In case of a criminal wrong, the criminal proceedings against the accused are brought by the state. Now, I'll bring in a few elements so that we understand basic of law also here. See, in case of civil wrong, the term used are plaintiff and defendant. In case of crime, the word used are accused and the state. A crime is considered to be a wrong against the state itself. So the state brings in an action. In civil matters, the state is not the party. It is the private parties who will deal with it. In case of a criminal wrong, the individual who is the victim, so the accused and the victim of the crime, is not compensated. You do not pay money. So if somebody is murdered, a compensation may be as a penalty, but the person is punished. Justice is administered by punishing the wrongdoer in such a case. So you put up behind the bars. If somebody hits and runs, hit and run case also a crime, state is involved. However, if I wrongfully enter your property and cause damage, you will not put that person in jail unless you go under the criminal law. If you go under torts, you will get a remedy of damages of money. Now, it is possible that the same act done by a person may result in two wrongs, a crime as well as a tort. In both, the civil and criminal remedies would be concurrently available. Both will be available. There would be a civil action requiring the defendant to pay compensation, as well as a criminal action awarding the punishment to the wrongdoer. So, for example, if I hit and run, the victim's family will also get money as compensation, and the person will also get jail. Whoever has done the wrong will also be jailed. Now, what is the difference between tort and crime? The wrongs which are comparatively less serious are considered to be private wrongs and are labeled as civil wrongs, whereas more serious wrongs have been considered to be public wrongs and known as crime. If I defame you, if I say bad things about you, it is considered to be a civil wrong generally. But if I kill somebody, if I steal somebody's property, all those things, or if I steal somebody, hit somebody, attempt to murder, all these are considered to be heinous wrongs, wrong against person, and are classified as crime. Now, the rule applicable in case of torts are generally different from those in the case of crime. Crime has very strict standard of proof. Innocent until proven guilty. Beyond all reasonable doubts. Preponderance of liability nahi hota. It's not there. It is strictly you have to prove completely that the person is wrong. For if you can let go of one person also from going into jail, you will prevent that. Correct? Now, since tort is considered to be a private wrong, the injured party himself has to file a suit as a plaintiff. If at any stage the injured party likes, he may agree to compromise with the tortfeasor and withdraw the suit filed by him. See, it's a private wrong. I do nuisance. I create a lot of noise. I cause problems. That problem is caused to me. So, to you, I do that. I cause that problem to you. So you might file a case against me. If we compromise and adjust and I say, okay, fine, from today onwards, I will not do anything like this. I will not make noise pollution. You might withdraw the case. However, in the case of a crime, even though the immediate victim is an individual, the crime is considered to be a public wrong. Wrong against the public at large or wrong against the state. Why state? Because what might happen is the entire state might consider themselves to be unsafe. If somebody is murdered in a locality, the entire locality considers that I am not safe. And in that case, it is the duty of the state to make people comfortable and safe. And that is why it is a wrong against public at large. Criminal proceedings are against the wrongdoer, therefore not brought by the injured party but by the state. Moreover, except in certain exceptional cases, the law does not permit a settlement in criminal cases between the wrongdoer and the aggrieved, and thus the compounding of an offense is, as a general rule, considered to be unlawful. So if you have said something wrong against me, a defamation case can be filed. And I can withdraw it also. We can settle on that also. Correct? However, if there is a crime which has happened, you cannot settle or you cannot compound unless the law permits compounding of that wrong. So unless and until law permits it, you cannot do. In the case of tort, the ends of justice are met by awarding compensation to the injured party. Correct? As I said, injury is remedied by unliquidated damages. So what are those unliquidated damages? Compensation. However, in case of a crime, the wrongdoer is punished. You generally put them behind the bars. The idea of awarding compensation to the injured party under civil law is to make good the loss suffered by him. So any loss suffered by that party will be made good. The punishment under crime protects the society by preventing the offender from committing further offenses and deterring him and other potential offenders from committing the wrong. So you do not deter the person who has done it. but also the society, anybody potentially who can cause injury, are also deterred from committing those wrongs. Therefore, crime is against the state at large, where there is no unliquidated damages or compensation, so as to say. The punishment is generally penal, and you try to deter the person doing it and the society at large. You set an example for the society. Now, the next part was, we've understood what is a civil wrong, tort is a civil wrong. Now, the next part is, tort is other than a mere breach of contract or a breach of trust. Now, you have to understand that there are various categories of wrongs. Now, we will understand what is a mere breach of a contract or a breach of trust. If a wrong is a civil wrong, it has to be further seen if it exclusively belongs to another category of recognized wrong. So, for example, another category of recognized civil wrong. What are those two categories we are considered with here? A breach of contract or a breach of trust. If it is found that it is neither a mere breach of contract nor a civil wrong like a breach of trust, then we can say that it is a tort. It may be noted that there is a possibility the same may amount to two or more civil wrongs, one of which may be tort. Okay, since both the wrongs are civil wrongs and damage is the main remedy for any kind of civil wrong, the plaintiff can claim damages under the law of torts for negligence or a breach of contract of bailment. So, for example, you've kept a watch with me under the law of bailment and you told me to take care of it. I did not take care of it and I was negligent with it. And I caused damage to that watch. You can either go for the breach of contract of bailment and sue me under that, or the breach of law of torts for negligence and sue me under it. You cannot claim damages under both. See the difference here between breach of contract and torts, and a tort and a crime. You can simultaneously go under the law of crime also and tort also, but you cannot undergo simultaneously between both civil wrongs. Next, a breach of contract results from the breach of a duty undertaken by the parties themselves. The agreement, the violation of which is known as the breach of contract, is made by the parties with their free consent. Now, another important thing here is that in torts, we've understood that the liability is owed to people in general, the public in general. However, if there is a contract, there are only two people involved. If X contracts with Y to sell wheat to Y, there is no Z which can be a party in this. X and Y have voluntarily, with their free consent, entered into the contract. Correct? There is an agreement between X and Y to sell the goods. There is no contract between X and the public in general that he will sell it to everybody. So this contract is between two people. This is another difference between a tort and a contract. So if X does not supply the wheat to Y, or Y does not pay the money to X, this will be a breach of contract and will come under the law of contracts. So this is a voluntary obligation taken by the parties themselves. Next, a tort, on the other hand, results from the breach of such duties not undertaken by the parties themselves but imposed by law. The law imposes a duty on us not to drive rashly, not to act negligently. The law imposes a duty on us not to cause any defamation to anybody, not to speak ill about anybody. Law imposes a duty on us not to enter into somebody's land unnecessarily. Correct? In a contract, the duty is based on privity of contract, and each party owes a duty only to the other contracting party. What do you understand by privity of contract? Privity of contract is that the contract is only between two parties. These parties are privy to the contract, X and Y. X has agreed to sell wheat to Y. Y will pay the money to X. I am not involved anywhere here. However, in torts, the duty is owed to everybody. Correct? Duties imposed by law under the law of torts are not towards any specific individual, but they are towards the world at large. However, even in a tort, the only the person will be entitled to sue who suffers damage by the breach of duty. I am under a duty not to defame anybody. If X and Y are people, and X has a duty under the law not to defame anybody, and he defames Y, only Y can bring an action here. Z cannot go and say, no, X was under a duty under law not to defame Y, so why did he defame Y? It is only Y who can bring an action against somebody. If X assaults Y, only Y can bring an action, whereas X is under a duty not to assault anybody around. Now, the damages is the main remedy both in an action for the breach of contract as well as in an action for a tort. The damages in a contract may be liquidated, whereas in a tort they are always unliquidated. X sold wheat worth rupees 10,000 to Y. Y had to pay rupees 10,000. Amount of damages would be 10,000 plus some additional amount for legal expenditure or for the inconvenience caused. But I have a duty not to, so X has a duty not to defame Y. Correct? X has a duty not to defame Y. Is there any monetary amount here involved? There is no monetary amount involved here. The court, depending on the kind of thing said, the magnitude of damage, and the circumstances involved, will decide the amount of money involved here. Okay? Next. In case of a breach of trust by a trustee, the beneficiary claim such compensation which depends on the loss that the trust property has suffered. Now, in case there is a trust, the damage will be based obviously on the amount of loss caused to the trust property. The amount of damages being ascertainable before the beneficiary begins the action, the damages in trust are also liquidated. Now, what is a trust? So, for example, X has some property. X puts it in the form of a trust. A trust is legally created. There's a method of creating a trust under the Trust Act. He creates a trust for the benefit of X, creates a trust for the benefit of Y and Z, and puts A as a trustee. A is going to be the trustee taking care of it, and X and Y and Z will be beneficiaries of it. Now, if any damage is caused by A to the property in the trust, you can obviously identify the money involved in there, and hence they are liquidated. On the other hand, we've already understood that in torts, it is unliquidated. Now, there's another way of understanding the difference between trust and a tort is by differentiating tort from breach of trust, because trust is with regard to a whole different law as a division of law of property. Now, there's another way of differentiating how trust, another way of differentiating tort from the breach of trust is to regard the whole law of trust as a division, the law of property, which is fairly detached from other parts of our law. So trust is basically with respect to property. You put properties in trust or some assets in trust and you use it. Now, this is only a historical reason because torts had origin in common law and torts had origin in common law, breach of trust had it in the court of chancery. This is a historic division. Now, the last part. Tort is redressable by an action for unliquidated damages. We've quite understood it quite in detail, what are liquidated damages, what are unliquidated damages, but I'll still explain. Damage is the most important remedy for tort. Damage is that the compensation which is paid. After the commission of wrong, it is generally not possible to undo the wrong which is caused. If somebody is defaming me, I cannot go back and say, now you stopped. Even if you stop defaming me, that information or that thing has gone around. So what is now required to do is that you pay money so as to help me for this. The only thing which can be done in such a case is to see what is the money equivalent to the harm by way of defamation. And the sum so arrived is asked to be paid by the defendant to the plaintiff. So you pay money to compensate for the wrong. There are other remedies also which could be available when the tort is committed. For example, injunction. So somebody is causing a nuisance. I will put in a remedy of injunction, stopping those things. Now, damages are unliquidated, and we've understood unliquidated means not decided, pre-decided. Unliquidated. Any damage which is pre-decided would be liquidated, and anything which is not pre-decided would be unliquidated. And in breach of contract and breach of trust, the damages are pre-decided because the quantum, the amount of service or goods in a contract and the property in a trust are pre-decided. It is fixed. So any damage to those, or a loss of goods, or breach of contract, or deficiency in service, or a deficiency in providing services, or breach of those, non-payment, everything is decided beforehand. It says liquidated damages means such compensation which has been previously determined or agreed by the parties. When the compensation has not been so determined, but the determination is left to the discretion of court, the damages are said to be unliquidated. We will, under the topic of remedies, deal in detail how damages are decided. But if they are predetermined, they are liquidated. If the court decides it after the wrong has happened, they are unliquidated.